And now your host, Patrick Smith.
Good morning and welcome to our St. Patrick's Day edition of the Attorney Patrick Smith Show. We're very happy to be with you. Today is Saturday, March 16th. We'll be with you for the next hour to answer all your legal questions. If you want to hop on the line now with your legal question, 877-943-9673. 877-943-9673. Our St. Patrick's Day PSA for you. Before you go and grab that leprechaun this St. Patrick's Day, you may want to look twice, because while leprechauns may or may not be real, assault and battery definitely is. So 877-943-9673. Give us a call now. We're live and local, happy to help any way that we can. It's been an exciting week at the law office and lots of thank yous to give out. Thank you to the Kiwanis Club of Claremont for having me out this week. Absolutely fantastic crowd, fantastic Q&A. Enjoyed our time there this past week. In addition to that, we also had the opportunity to appear on our buddy Brandon Rhymes show, The Consumer Quarterback. So we appreciate Brandon's invitation, and we'll be booking him on our show here before too long, as soon as we can get everything coordinated. So for today's broadcast, in addition to answering all your legal questions that come in, and that number again, 877-943-9673, or email me, Patrick at attorneypatricksmith.com. For those of you who are new to the show, by the way, I'm Attorney Patrick Smith, local Central Florida attorney offices throughout the state. And our primary practice area is estate planning, wills, trust, wealth transfer, asset protection, that sort of planning day to day. And a few weeks back, when I was up in New York City and we were broadcasting from the New York City studios, we did a segment called Estate Planning Across the Nation, and we did our first feature state, which was the Empire State, and we had attorney Ken Henry on, focusing on the differences and similarities between the laws of Florida and the laws of New York. And continuing in that, today we are going to focus on the similarities and differences between the laws of Florida and the laws of Massachusetts. First of all, a little background information about the state of Massachusetts, for those of you who may not be familiar. Massachusetts' nickname is the Bay State. They became a state, they're actually the sixth state, and they became a state in 1788. Population, well, this is a little outdated, roughly 7 million-ish people. The capital is Boston. That's also the biggest city. And the state bird, so you get this right on Jeopardy, is the black-caped chickadee. And the state flower, of course, the Mayflower. So a little background, but to aid us in our discussion, since I am but a Florida licensed attorney, we have a very special guest joining us on the hotline. And Yumiko, I can't see the call screener. Can you pull that up for me? Thank you. We have a very special guest joining us on the hotline. He's been a friend and buddy of mine for years now, and worked with him on several cases. His name is Warren Yanoff, and he has over 40 years experience practicing Massachusetts law. He spent over a decade as a consultant with a multinational financial institution advising high net worth individuals regarding estate planning and business succession planning, certified divorce mediator, 17 published opinions from cases at the Supreme Judicial Court and Massachusetts Appeals Court, and has bar admissions for Massachusetts, Florida, U.S. Supreme Court, U.S. Court of Appeals, First Circuit, and he was named Lawyer of the Year in 2013 by Massachusetts Lawyers Weekly. Ladies and gentlemen, join me and welcome to the show, my friend, attorney Warren Yanoff. Warren, welcome to the show, buddy.
Good morning.
How are you? How's the weather in Massachusetts today?
We have an early spring and it's a little chilly, but it's really nice and sunny here.
All right. So Warren is, like we said, a practicing Massachusetts attorney. So he will be here to field the Massachusetts side of any of your legal questions. If you are snowbirds who have a property in both jurisdictions, we'll let Warren take the Massachusetts side of the case. And then, of course, I will address all the Florida issues as well. So if you have a question this morning for either myself or Attorney Yanoff, 877-943-9673. Warren, I thought we'd start with just a simple question. What does it take to make a valid will under the law of Massachusetts?
Basically, I'm sure it's very similar to Florida. You need to be confident you need to be over 18, and you need 2 witnesses. In addition to that, what is usually done, we have self-authenticating wills, which would require a notary. And basically, it's that simple. Obviously, you have to, when you execute it, you need to know what you're executing and that you did it freely and voluntarily.
Well, and I love things like this where, it's so similar between Florida and Massachusetts because Florida law, similar to this, signed by the testator, by someone who's competent, and signed at the end of the document in the presence of 2 witnesses makes a valid will. And then there's the additional step for what we call a self-proving will, which is also witnessed, notarized, self-proving affidavit. How similar those are, I think it kind of shows the common law origins, how all the states, while there may be variations between the states, we all go back to the common laws of England. And I think that when you come to will making, that's some of the oldest laws. And it's a very static area of laws in many ways. There's not a lot of movement in wills and trust. And I think when you go to the requirements of what it takes to make a will and you see the similarity between the states, I think that's sort of evidence of that commonality involved in our common law origins.
Just one other thing. Massachusetts has, for the most part, adopted the Uniform Probate Code. So most things are very, very similar.
Yeah. Yeah, I know there was a move, and I know Florida's response to that was back in October of 2011 with regard to power of attorneys, where they sort of transitioned a step closer to something like that, just to have uniformity among the states. And I know some people, that's a hotly debated matter, whether or not there should be uniformity among the states or whether or not, we lose integrity between federalism by having this sort of, similarity across the state by statute. So I know people go back and forth on that, but if you have a question for Attorney Yanoff about your will in Massachusetts or a question for me, any legal question at all, 877-943-9673, 877-943-9673. You can give us a call now, live and local. Patrick at attorneypatricksmith.com is your email address. If you want to shoot us an email, we'll be happy to read your question on the air and get to it when we can and have Attorney Yanoff or myself answer the question. So the other thing, and this came up at the law office this week, Warren, was what are the requirements to be does Massachusetts use the term personal representative or does it use the term executor, executrix? What's the official office called under Massachusetts statute?
We now use personal representative.
So you use the gender neutral term too, which I think is also a move in the uniform code direction as well. What are the requirements?
It doesn't matter whether you are testate with a will or intestate without a will.
And so what are the requirements to be a personal representative under the laws of Massachusetts, if any?
Basically, you need to be an adult and you do not have to be a Mass resident. If the person in a will, you can designate who you want or what I'll say financial institution or professional you want, but it does not have to be a Massachusetts resident at this point.
Now, here I think and by the way, if you're just joining us, this is the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. Joining us via telephone is practicing Massachusetts attorney Warren Yanoff, and we're doing our Florida, Massachusetts analysis, comparing and contrasting the different estate planning aspects between these two jurisdictions. I think here's where we get our first difference, Warren. So if you are a convicted felon in the state of Massachusetts, can you still serve as someone's personal representative?
There's no technical prohibition. Obviously, you would have to have standing. So basically, in a will situation, if someone designated a convicted felon, you could be, if nobody objected, they would most likely just process it. To the extent, which is a little different than if you were appointed a conservator or a guardian, where they would carry a criminal's record check, and that probably would disqualify you. They do not do criminal record checks when you are appointed personal representative.
So in Florida, we have something called an oath of a personal representative, which is basically you swearing under penalty of perjury that you meet the requirements to serve as someone's personal representative. Does Massachusetts have a similar process where you're basically having the party that petitions to get appointed confirm through some sort of affidavit or affirm to the court that they meet those requirements?
No.
So the court does the analysis on their own, or it's through the petition? What's the process?
You do the petition. The petition list, you have to list who has, quote unquote, priority. So that would be, for instance, if someone were married, it would be the spouse. If someone were not married, it would then be the children. If they weren't married, didn't have children, it would be first parents. And then if they had no parents, it would be siblings and go on. It's basically the laws of intestacy gives people priority. And you have to list all the people who are given priority. They may assent to one of the people or not, and they would have a right to object. You could have competing petitions so that, let's say, brother and sister didn't agree. Each one could file a petition, and then the court would determine which person, if either one of them would be suitable. It is also possible in, I'll say, a contest that the court would appoint a neutral third party to be the personal representative.
Did you just allude to the fact that siblings might not get along in their parents' estate administration warrant? Does that actually happen?
Well, more times than we'd like to want.
It happens often, and we hate to see that, but it's oftentimes when that breaks out. And you can tell me about how much it happens in Massachusetts. I find it here when that dispute in a will contest breaks out. Everyone sort of gets a hard and fast lesson in something called the economics of litigation. Do you see that in Massachusetts as well?
Oh, absolutely.
Yeah.
I mean, and so it's about, if hopefully somebody has addressed it in a will, but the real issues have to do with mostly intestate, and sometimes parents put one child on a bank account or on the property and saying, well, when I go, you'll take care of your brother or your sister. And that usually doesn't happen. At least in Massachusetts, if there's a presumption that a joint owner of an account, that becomes that person's property unless there's some, evidence, sometimes in writing, sometimes witnessed orally, that was intended for convenience only.
Yeah, Florida has something similar here where if a bank account, and it's actually not governed by the probate code at all, it's actually a banking statute that says if it's jointly held, it's presumptively owned by the surviving owner of that account. If you are listening and you have a legal question for Attorney Yanoff regarding Massachusetts law, or Attorney Patrick Smith, that's me, regarding Florida law, you can call in now, live and local. Call screener standing by to screen your calls, get you live on the air with us to ask any and all legal question. No legal questions off topic. 877-943-9673. That's your toll-free studio line. We're live in studio with you today. Call screener standing by. Happy to take your question, give you the very best answer we can on this St. Patrick's Day edition of the Attorney Patrick Smith Show. 877-943-9673. I want to circle back, Warren, to something you said about so long as you have standing, you can serve as personal representative. Maybe give an example of someone who did not have standing to serve as a decedent's personal representative.
Let's say that somebody had a brother or a sister, some cousin or nephew would not have standing. That doesn't mean that they can't petition to be the personal rep, but they do not have priority. You have to have some reason to want to do that. If someone were incompetent, for instance, for some reason, and were under a conservatorship, conservator does have standing to petition to be the personal representative. However, we have a separation of guardian and conservatorships. A guardian does not have standing to petition for personal representative.
So someone who doesn't have a standing, in Florida, there's something called a majority and interest rule. If the majority of the interested parties sort of vote in favor of this person, does something similar apply in Massachusetts? So if you got those interested parties who have the priority to say, yeah, we're okay with this person being the administrator, is the judge more than likely going to approve that?
Absolutely.
Okay. Yeah. So that's similar between the states. If you have
It's not necessarily a majority, but again, you file it, you send notices to all those people who do have priority, who are interested, whether in the will or in testing, and people can have a certain period of time to file an objection to that individual being appointed, and then there's a hearing if necessary.
All right. So 877-943-9673 is your live and local studio line if you want to call in with that question. 877-943-9673. Now, Warren, when we were talking about this broadcast, this was really the meat and potatoes of the presentation we were going to do today for the listeners. It was regarding taxes, because I think here is really where we get the chasm of a difference between Florida and Massachusetts. So I'll let you lay out first Massachusetts law regarding both income and estate taxes, and I'll just turn it over to you for a couple of minutes so you can sort of unpack that infrastructure for our listeners.
Basically, we have income tax and estate tax. Income tax, basically around 6% of your income. And it follows pretty much along the federal tax limits. You put in your tax at a little different rate for capital gains, things of that nature. The estate tax, however, is very different, both from the federal and obviously in Florida. We do have an estate tax. Up until last year, it was $1 million, and that $1 million, if you exceeded the $1 million, it actually disappeared. So if you had $1.001 million, you actually got taxed on the first $1 million, on the dollar. That changed last year. Now $2 million, and it doesn't disappear. So basically, if you structure your estate properly, you could give away approximately $4 million estate tax free. The other significant issue is if you are a Massachusetts resident and have property in any state, any country, you are taxed on your global assets. Such that if you had only, let's say, $1 million in Massachusetts, but you had $7 million in Florida, you would be taxed on the $8 million. There would be a percentage what you would pay in taxes, but since Florida doesn't have an estate tax, you'd be taxed on $8 million in Massachusetts. Conversely, if you are a Florida resident and you had $7 million in Florida and you had $3 million in Massachusetts, you would still have to file a tax return in Massachusetts to clear the property, but you would only pay a percentage of your entire estate. So that would be, in a sense, 30% of the estate tax.
Yeah, and the Florida side of this is basically we have neither. We don't have an income tax, we don't have an estate tax, so it's pretty simple for people who are just Floridians. But it sounds to me like Massachusetts and the Department of Revenue there have really earned that nickname of Taxachusetts with this sort of more aggressive approach with regard to that global application of the pool that's taxable as far as assets go for all Massachusetts residents.
That's correct. There is one way. If you're, say, a Florida resident or an out-of-state resident, if you held the property in, say, a corporation or an LLC or probably an irrevocable trust, that property would not be included for mass estate tax purposes.
Yeah, and we talked about that off the air, saying if you do the irrevocable trust, unlike the revocable trust that we typically do for a lot of non-tax estates, with the irrevocable trust, because that's a completed gift, technically, we were talking about how you just dip into the unified credits and allocate them on a timely filed 709, and that way you don't dodge an estate tax to run headlong into a gift tax scenario. If you have a question on the Florida, Massachusetts estate tax laws, income tax laws, or any other legal question, 877-943-9673. Again, this is the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. With us on the hotline, our very special guest, attorney Warren Yanoff, 40 plus years experienced Massachusetts law attorney, here to speak to the laws of the great state of Massachusetts. Warren, do you have time to take a call with us?
Yes, I do.
All right, let's go to Nick somewhere in Florida. Where are you in Florida, Nick?
I'm in down in Holmes Beach, which is Bradenton area.
All right. Well, Nick, thanks for calling in. You have a question?
Yes. If I create a will in Florida and family up in Massachusetts, can they serve as my executor?
So the question is, can your family in Massachusetts serve as the personal representative on your will in Florida?
Yes.
Yeah, they can. So under the Florida guidelines, the sort of way to paraphrase it is anybody who's not a felon and fits into one of these three categories essentially is a blood relative, spouse of a blood relative, or Florida resident can basically serve as your personal representative. So you said family, if they're family of yours, they can basically serve and live in any jurisdiction, even all the way out in Timbuktu. It's a matter of the fact that they fit under that blood relative category, and that's going to allow them to serve in that capacity. So, Warren, did you have anything to add to that?
No, I mean, that's accurate, and it would be, the reverse would also be true in Massachusetts.
And Nick, where about in Massachusetts is your family?
Well, he's in Boston. He's actually an attorney there. So, I was trying to figure out if I created a will here, if, like I said, he's up there, and I didn't know if, he wouldn't be obviously practicing here as an attorney. It would be just as an executor. But, and the other question, if you have the time.
Yeah, go ahead, Nick.
If I created a trust in Florida, and for some reason or other, I moved to another state, would I have to dissolve the trust and create another one in another state? Or can that Florida trust still be in effect?
Yeah, this is the most common question we get at the law practice or at speaking engagements when we do Q&A, Nick. And the short answer is, if you do a document, and I'll let Warren speak to the Massachusetts side of this and confirm this, but if you do a document that's valid in any jurisdiction, there's reciprocity among the states. So if your Florida trust is valid in Florida, it's going to be valid in any of the other states and U.S. territories you go to. However, don't rest your head permanently on the fact that it's valid. One of the biggest mistakes in estate planning is people don't do it, but a very close second, Nick, is people do not update what they've done. The way you maintain optimization in estate planning is by periodically updating. I tell my clients every 3 years at the most, just cyclically, you want to review the family, the finances, the documents, the laws, make sure everything's still optimal. Even if that meeting's 10 or 15 minutes and you didn't do anything, that way you catch any issues, and heaven forbid you have a situation where you didn't address something, it festers and something turns into this catastrophic situation for your family. So this is what I tell my clients who are going to different jurisdictions. Have the document reviewed by a licensed attorney in that jurisdiction. Not for validity, we know it's valid, but have them see if there's anything that they should tweak to make the document more efficient for that jurisdiction. There may be a law there you're not taking advantage of because it was drafted in Florida. Does that make the document invalid? No. But you're not taking full advantage of all the efficiency options in that jurisdiction. So I think it's a matter of having it reviewed by local counsel to get their opinion. You may want to get a couple opinions just to sort of see the spectrum, if they both say the same thing or if they say completely different things. And I think that's my best answer to that. Warren, did you have anything to add?
Yeah, it depends on a lot of times who the trustees are or trustee. For instance, if you chose as trustees Florida residents, and you move to Wisconsin, it's still really a Florida trust because the trust is situs where, for the most part, where the trustees are located. So that while you may move, if you're not the trustee, it still stays as a Florida trust.
Yeah, and just to clarify, because Warren, not everybody may know the term situs. Situs just means what law governs. So what Warren was saying, if you have a Florida trust and you go to Wisconsin or any other jurisdiction, it's going to remain a Florida trust. And his point is, if you're going to be full-time in Wisconsin, that's a great example. That doesn't invalidate the trust, but it could make it a little clanky because now you're a Wisconsin resident operating a trust in Wisconsin that's governed by Florida law. So it's a matter of updating that to streamline that efficiency. That's kind of what you were speaking to, Warren, right?
Correct.
Yeah. So, Nick, any other questions for you?
Oh, that should do it. You guys do a great job. I appreciate it very much.
Well, Nick, you're very kind. We appreciate your kind words. Thanks so much for listening.
Thank you.
All righty. 877-943-9673. Warren, I don't know what it is about you, buddy, but the phone lines have lit up. So if you want, we'll just keep taking some calls. You good with that, Warren?
Yeah. Oh,
All right.
absolutely.
By the way, Warren, I was thinking about this before the show. How long have we been working together?
I think more than 20 years.
It's been a long, because your daughter had not yet gone to undergrad. Like
Absolutely
she
not.
was just getting ready for undergrad, I think, when we first started working together. And I won't ask you to give out your daughter's age.
Then I apologize. And that's probably only 15 years.
Yeah, that sounds more, because I've been in practice about 17 and a half years. So that sounds about
Oh, okay.
And I don't remember how we got connected on that very first case.
I can tell you.
Well,
You represented.
don't say any names, whatever you
It was
do.
a trust.
Okay.
And there was obviously litigation. And I represented. We were somewhat on the same side, but we had different. We represented different individuals, beneficiaries of a trust, and there was a creditor.
Yeah, that's right. I remember that one. Now, and your paralegal, her name is Diane. Is that right?
Gail.
Say that again. Gail. That's what it was. I remember when I called up there for the very first time, Gail answered the line, and I loved her accent because she thanked me for calling the law office. And I was like, law office? Do they add an R to law office up there? So, I mean, it was just fascinating, but she was so charming and delightful. And she's still with you, right?
She is still with me.
Well,
Been with me for 32 years.
She's a treasure, and I love talking to her every time I get a chance. And eventually I will learn her name's Gail and stop calling her Diane. I don't know where I had Diane from, Warren. But anyway, we're chock full of calls. Let's go to my hometown of Winter Haven, and let's talk to Rhonda. Rhonda, welcome to the Attorney Patrick Smith Show. How can Warren and I help you today?
If you are unexpectedly hospitalized in the state of Florida and you're a non-resident, does the DNR that you brought with you from your state do what's intended?
That's going to be up to the doctor. The DNRs are really more for the physicians to look at and decide if they're going to honor it or not. And I think it's really going to be up to each and every medical doctor. Now, if it's, did you really mean do not resuscitate order, or did you mean living will? Because there's a difference there in Florida.
No, I mean do not resuscitate.
Yeah, so do not resuscitate orders are regarding your cardiac function in Florida. And it's really a pre and post cardiac event treatment plan that you craft with your physician. The physician signs, you countersign. A living will says, hey, if I'm brain dead, I don't want to be artificially prolonged. So I think with a straight DNR, that's issued by a medical doctor. I think it's going to be up to the doctor to look at the document and decide if they want to honor those wishes.
Okay, so a living will, then I guess I didn't understand. So could you tell me what a living will means in the state of Florida?
Yeah, great question. So the design for a living will under Florida public policy is basically when you do a power of attorney and healthcare surrogate to, say, a spouse or a child and say, I want you to make all these financial and medical decisions for me. The living will is where you call one decision back and you say, there's one decision I never want to worry about you making and burden you with. So I'm going to go ahead and make that decision now. And I'm going to put in writing that if I'm found permanently brain dead with no chance of making medical recovery, according to not one, but two medical doctors, you do not have to decide if I live or die because I've already made the decision. All you have to do is honor that request. Make sure I'm not in pain, give me all the pain medication I need, but do nothing heroic to prolong my life and let me go to eternity. And that is the way that you pass that gift along to your loved ones so that they don't have to live with having made that final decision for you. Does that make sense, Rhonda?
It does. So I guess then I need to look at the verbiage in the living will that was created in Michigan to see if it reads to Florida's.
Yeah. And we've got an office right there in Winter Haven on the Haines City line there at the South State Bank building. And I've got enough counsel attorney Jared Bailey who's helping me out with those clients. So if you give the office a call, I'll give out the office line here during the show. Jared will be happy to sit down with you free of charge, review everything, and give you his thoughts. Okay.
Okay, perfect. Thank you very much.
Rhonda, how's the weather in my hometown today?
It is beautiful.
Oh, that's what I love to hear.
Beautiful.
Rhonda, take care of Winter Haven for me, okay?
I certainly will.
All right, Rhonda. Thanks for calling in. All righty, 877-943-9673. For those of you just joining us, this is the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith, and joining us on the phone is Attorney Warren Yanoff. We're continuing our estate planning around the nation segment, we are now following up with state number 2, and we are doing the state of Massachusetts. Joining us, Attorney Warren Yanoff, licensed Massachusetts attorney. If you have a question for Warren or myself, 877-943-9673. Before we move on to the next call, Warren, would that answer have been different in Massachusetts regarding DNRs and living wills?
Well, we don't use living wills.
What do you use?
We use a healthcare proxy. And the healthcare proxy can be as limited or as broad as you want. So it would do DNR. It would also do comfort measures only, do not resuscitate, do not intubate. It can express all your wishes, if you will. It does not require validation by a doctor. Usually the doctor or the hospital would want you need a letter or an opinion that the person is no longer competent. Even if you make the healthcare proxy, let's say you become incompetent and then regain competency, let's say from a stroke, you are still the decision maker as long as you are competent.
Okay. And just so I keep my word to Rhonda, that office line, if you want to reach me during the week, is 877-754-6764. The toll-free office line, if you want to book your complimentary consultation, 877-754-6764. And yes, I know appointments fill up fast. And if you want to call, that's the line for Sarasota, Clearwater, Sun City Center, Haines City, Winter Haven, Claremont, any of our office locations, 877-754-6764. So, Warren, we may have people listening who are looking for a Massachusetts attorney. So how would they get in touch with you if they're interested in sitting down and talking with you?
2 easy ways. My office number is 508-797-4755. And my email is yanofflaw, YANOFFLAW
All righty. And if you want to be part of today's show, that number, 877-943-9673. I'm Attorney Patrick Smith. This is the Attorney Patrick Smith Show, and we have our very special guest, licensed Massachusetts attorney Warren Yanoff, joining us on the hotline, answering all of our legal questions that are coming in today. Let's go to our next call. Let's go to Gina in St. Pete. Gina, welcome to the Attorney Patrick Smith Show.
Hi, thank you. Good morning.
Good morning, Gina. How can we help you?
I think I'm your target audience today.
Oh my gosh, I can tell by the accent. Gina,
yes,
I can tell
exactly.
Gina, real quick. You sound like a fun person. Can you repeat after me? Park the car in Harvard Yard.
Park the car in Harvard Yard.
I love it.
We'll go to a wicked good concert tonight.
That was my next phrase. I was going to say, can you please repeat after me, Gina? Can you say wicked awesome?
Wicked awesome.
Yeah, I love it. Gina, it's fantastic. Don't ever lose the accent. It's charming. It's endearing. How can we help you today?
Okay, I am the personal representative of my sister's estate who passed away in Massachusetts.
I'm sorry about your sister, Gina.
Yes, thank you. I filed her IRS tax return for 2022 in June of 23. Is it unusual that the IRS is still processing this? When I inquire December, January, and February, they have not requested any other documentation, but they did say to give it 30 days. Is it unusual that there is this much of a backlog?
Now, Gina, before I turn it over to Warren, one follow-up question quickly for you. Do you currently have counsel representing you with regards to this?
I do have both a trust lawyer and an accountant.
Okay, so I'll let Warren decide in light of the fact that you're represented by counsel if he wants to answer that or not. So, Warren, I'll turn it over to you.
Well,
Thank you.
Are you talking about, I just want to clarify, you're talking about an income tax return or an estate tax return?
The income tax is what I'm talking about now. We haven't filed the state yet.
An estate, or I'm not talking about the Massachusetts state income tax, I'm talking about whether the Massachusetts estate tax, if that was necessary. In other words, I can't answer that with regard to the income tax. I can tell you that getting clearance to some extent, if this is a Massachusetts estate taxable
Yeah.
estate.
She falls in under the $3 million mark, if that's what you mean.
Well, she died in, you said 2022 or 20?
2022, January. So I think it's
She has $1 million.
retroactive.
It would be, she would have, assuming that she was not married. I meant to say, if she were married, there's an unlimited marital deduction. We do have that. But if she was not married, she would have effectively $1 million limit at that point. So if,
Okay.
if assets were worth more than $1 million, she would have to file a Massachusetts estate tax return, and that sometimes takes a while to get. It's called a closing letter.
So does that have anything to do with her personal IRS return?
Yeah, her federal return, Warren, is what she's wondering about. And-
Right.
Yeah.
I don't believe that those are linked in any way, but I'll defer to the accountant.
Yeah, I think
Okay,
you turn
and-
to your accountant on that, but just in general, not commenting on your specific case, Gina, because it's certainly outside of my jurisdiction. And like you said, you already have counsel. So I encourage you, just go back to your counsel and ask them directly what the delay is. But we are seeing a backlog at the IRS. So it's just the nature of the beast right now. They're just so far behind, and they are starting to make some headway in catching up. But it sounds to me like it's probably typical delay. But again, go back, check with your counsel. Odds are they're doing everything they can, and it's just, bureaucratic backlog.
Great. Thank you so much,
All
both
right,
of
Gina.
you.
Sorry again about your
Yeah.
sister. Okay, we'll be praying for you guys.
Thank you. And I listen every week. And if Warren could just say what region of Massachusetts he's in.
I'm in the Worcester area, but I do things for estate purposes throughout the state.
Okay, good, because we're on the North Shore.
That's nice there too.
And for those of
Okay,
you who want to
good.
spell Worcester, it's like Bruce Springsteen said, right, Warren? It's WOOSTA. Is that Worcester?
For some people.
That's right. There was a famous story about Bruce Springsteen having the city he's in the inside of his jacket, and he would look in, and I think you were the one who told me that story about the PA didn't know how to spell Worcester, and so he spelled it like they said it, Worcester, and it's WOOSTA, supposedly, according to the urban legend. Anyway, Gina, you've been a great caller. We appreciate you being a good sport.
Thank you, guys.
All right, have a great day. All right, 877-943-9673. Give us a call now. We're live and local. I'm attorney Patrick Smith. This is the Attorney Patrick Smith Show. On the hotline, attorney Warren Yanoff, licensed Massachusetts and Florida attorney. Got 2 law licenses there. Next, we're going to Gene in St. Petersburg. Gene, welcome to the Attorney Patrick Smith Show.
Hi, Patrick. I have a quick question for you about naming the beneficiary on a checking account and a money market account with a bank.
All right, Gene, the floor is yours.
I want to know if I can list, quote, the executive of my estate, unquote, or do I have to use the name of the person?
Yeah, I think you would need to be a little more specific, because here's my concern there. If you put down like the personal representative of my estate, they're probably going to have to go and get a court order to verify that they are in fact the personal representative. So I think by having them listed as a beneficiary, you're attempting to bypass probate, are you not?
For that part of it, yes.
Yeah.
I do have a valid will
Yeah.
in Florida. I'm a Florida resident.
So
I have no property outside of Florida.
So realize if you make that person the beneficiary and it pays to them, that pays to them personally. That is their money. It's not controlled by the will. So if the will says divide it in 3 equal shares, that's not what's going to happen with regard to those funds necessarily, because you named a beneficiary directly. The other concern I have about parties who over rely, on beneficiary designations, Gene, is it doesn't adequately address incapacitation. So beneficiary designation is fine if you're dead, but the statistics tell us that most of us will be incompetent prior to our passing. And they also teach us that the final 30 to 90 days of our life are the most expensive days that we ever live. So I think a lot of times when you're creating a plan, you often create a trust, and people talk about avoiding probate with the trust, which is true, but there are other advantages to the trust besides avoiding probate. And one of them is planning for your incapacity. So for instance, this same money market or checking account you're talking about, you could create a trust, which my office does for $695, and you could drop that into your non-tax trust, which fits any estate of less than 13.6 million. And now you're going to avoid probate. You also have contingent beneficiaries. That's another shortcoming on the beneficiary designation. You designated that person, but what if that person died with you or before you and you never updated? The trust will say, if this person's dead, then to these people. And it'll also give the successor trustee that you picked and entrusted with the responsibility of your financial ship should you become incapacitated, it will give that person and empower them with the ability to protect that asset, that checking money market account, from aggressive creditors like nursing homes to the fullest extent under Florida law. So I think your effort is well intended, Gene, but I think there's some more efficient strategies out there for you.
Okay, I appreciate it. What I was trying to do is just be sure that my personal representative or executive on my will has money to pay the bills for my final expenses and for the utilities on my house until it's sold, that kind of thing. I was just trying to make it easier for them.
Yeah. So under the trust, if you lose capacity, typically we set it up, and Warren, you can tell us if you do it differently in Massachusetts, but it's typically two doctors' letters, two medical doctors say, hey, this person's no longer competent. And then the successor trustee takes over. They can start paying bills, filing taxes, doing all that sort of good trustee fiduciary duty stuff. And I think that's probably the most efficient strategy. But Warren, anything to add from the Massachusetts law side for Gene?
Nothing to really add, but I just want Gene to be clear that is it his intent that in his case, the personal rep and or the designated joint owner is the only person who's going to get that funds? Because if it was intended to go to three people, that might not happen if he designates the individual's name alone.
Yeah. So Gene, any follow-up?
No, that's great. I really appreciate the time and enjoy your show. Thank you very much to both of you for your thoughts.
Well, Gene, thank you for calling in. Enjoy the rest of your Saturday. Have a happy St. Patrick's Day, okay?
Okay, bye now.
All right. And Josh, if you're still listening, call back. I was just about to go to you. You had a fantastic call lined up. So Josh, if you're listening, give us a call back, 877-943-9673. I was looking forward to that sort of firsthand empirical data that Josh was going to provide to the show. If you have a legal question, though, so plenty of time to get in with your call screener standing by, happy to help and get you on the air with me, Attorney Patrick Smith, and my special guest, Attorney Warren Yanoff, licensed Massachusetts and Florida attorney. 877-943-9673. That's your live and local number to be part of today's show. 877-943-9673. Warren, you can take a quick break. I'm going to do something that's a little unique to the show. I don't think I've ever done this on the show, but I don't see a rule that says I can't do this on the show, and it's my show. So I kind of feel like I can do whatever I want. I had someone reach out to me about helping them sell a car, and I don't have any finder's fee or commission in this, but I saw no reason why I couldn't help this person sell their car. So I didn't say I would say a name or anything. You can email me if you're interested in this, but we have someone selling an 08 Toyota Camry Solera 2-door convertible. And it is approximately 33,340. And the color of the car is white with black convertible top, gray leather seats. The asking price is $10,000. So if you have interest in buying a convertible Toyota Camry 08, 33,000 miles for $10,000, email me, patrick@attorneypatricksmith.com. I will pass along your information to the seller, and you two can connect, and hopefully we have a successful sale of an automobile. But, we had a call a few weeks ago, Warren. It was about something about a technical issue with the car, and I wound up giving someone automotive advice. And for some reason, I feel this gravitational pull to my show becoming about automobiles for some reason. I don't know why that is, but we just sort of lean into helping people however we can. And if we can take 30 seconds to offer to help you sell your car, we're going to do it. So again, you can email me, patrick@attorneypatricksmith.com, if you have an interest in buying a 2008 Toyota Camry Solera 2-door, 33,000 miles for $10,000. All right, I'll get that email and I'll pass it along to you. So 877-943-9673. That's your live and local number to be part of today's show. I'm Attorney Patrick Smith, Attorney Warren Yanoff on the line. Warren, before we take this next call, just give that, because once I get to the close of the show, I'll have to wrap up. I want to go ahead and give out your office information one last time. So for the Ginas of the world out there who may be looking for someone, what is the best way? You said there are a couple of ways to reach out to you. Go ahead and give out that information one more time.
Easiest way is my office phone number, which is 508-797-4755, or email me directly, and it's Yanoff Law, YANOFF LAW@gmail.com.
All right, and schedule your appointment with me, Attorney Patrick Smith. That toll-free line, 877 877-754-6764 for any of the office locations. 877-754-6764. Let's go to Monica. Monica, welcome to the Attorney Patrick Smith Show. What part of Florida are you in, Monica?
Lakeland.
All right, Polk County. How can we help you today?
Yeah. Okay, so I'm wondering if the will oversteps. So the will states that the bank account should be split amongst the 5 kids, but my name is on the will. I mean, my name is on the bank account.
Well, lucky
only.
you.
Well, but I've been sued saying that I was supposed to.
All right, you said the will says this bank account. Does it reference the bank account specifically?
His bank accounts, my father's.
Yeah, does it say this bank account at this bank is to be split 5 ways, or did it just say whatever's in my estate gets split 5 ways?
It says his bank accounts get split amongst the 5, but did not specific say which bank account it was.
Yeah, you may have to get an order determining beneficiaries there, because the banking code is going to say the presumption is that because you're the co-owner with dad, that belongs to you. But the presumption can be rebutted if the will specifically calls out bank accounts. If the will were silent and just had a rest, residue, and remainder clause that said equally among my children, I think you probably went out. But with it calling out bank accounts, the judge may rule and say it's 5 equal shares. So I think that may be a situation where you have to have a judge make a ruling regarding the determination of beneficiaries. So, Monica, I got to take one more call. Did you have any quick follow-up?
No, that you've just answered a big question for me. Thank you so much.
You're welcome, Monica. Have a great day. 877-943-9673. Quickly, Kevin in Venice. How can we help you today, Kevin?
How's it going?
Good, Kevin. I got about a minute.
Right on. Hey, shout out to Ryan Hoppy there, still answering the phones. Hey, I got a couch I'm trying to sell. Is there any chance we could work something out?
This was what I was concerned about, Kevin. Yeah, I'm not going to become the shopper line, but I appreciate you calling in. Yeah, I'm not going to.
It's leather.
All right, Kevin, I got to wrap up the show, but it was a great
Come on,
call.
dude. It's got a footrest.
All right. Kevin, enjoy the rest of your day. All right, brother. 877-943-9673. That's your live and local number for next week. Again, Warren, thank you so much for making the time out early on a Saturday morning to be part of the show. We really appreciate you and Gail and all you guys do for us. So thank you again.
Well, we appreciate you too, and thank you for asking me.
All right. We'll have you back on the show sometime soon, and enjoy the rest of your Saturday.
I will. Thank you.
You're welcome. All righty. So if you want to be part of the show next week, 877-943-9673. Next week, we will be live from Stetson University's Model Senate. So stay tuned for that. That'll be a very special edition. Lots of special guests lined up for that broadcast. So again, that number to call in next week, 877-943-9673, or call me at the office during the week for your complimentary estate planning consultation, 877-754-6764, 877-754-6764. Everyone have a fantastic St. Patrick's Day. Stay safe. God bless. And of course, go Gators.